welcome to acubeias. Today we are going to talk about the statutory bodies in India. The statutory bodies which have been making recent news or are in contemporary significance and demand importance and oversight from this examination point of view, we are going to discuss those statutory bodies. So basically, what are statutory bodies? Statutory bodies are those bodies which come from a statute. A statute, the law of the land, the legislature, which might be either the union legislature or the state legislature. So the legislature makes a statute, it makes a law, and with this law comes the emergence of the body. So why do we need to make this law? We have provisions in our constitution. The constitution has concepts of equality enshrined in various articles, starting from articles 14, 15, 16. All this have mandated that the state should be non-discriminatory. Our nation does not support discrimination. So that is one of the provisions in the constitution. Secondly, India is a welfare state. We have to take care of the general well-being of all the people. There should be no discrimination. So as a welfare state comes from the DPSP, for that we need regulatory or statutory bodies. Thirdly, as Indian citizens, apart from having fundamental rights, we have fundamental duties. These fundamental duties have mandated us, or not rather mandated us, they have asked us to maintain the spirit of brotherhood, the spirit of respecting our composite culture. And for this also, we need some body which will take care that all this is being done. And thereby, we have statutory bodies. Statutory bodies may be classified in a numerous number of ways. But we have, for the purpose of education, for extremely academic purposes, we have divided them into either quasi-judicial bodies or regulatory bodies. So what is the difference between the two? Regulatory bodies are those bodies which have a regulatory or supervisory capacity. A regulation which is not interfered by the state. So it is outside the executive observation. The executive has given its duty of regulation to an autonomous independent body, and this body is going to take care that regulation is done. So some examples: Pension Fund Regulatory Development Authority. Then we have a very important one which is coming in news very often, IRDAI, Insurance Regulatory Development Authority of India. So all these are regulatory bodies. Moving on, quasi-judicial bodies. So why quasi? Quasi means semi, which means it is not exactly like a judicial body. It has few powers of a judicial body, which means it can call for hearing, it can give a decision, it can pronounce jurisdictions, but it is quasi, which means it does not have absolute jurisdiction over everything. It has jurisdiction only in the acts or the legislation which gives it the power. The act which created that quasi-judicial body, that will empower it with certain functions. That will empower it with certain adjudicatory powers. And those quasi-judicial bodies are going to look over only on those issues. A very good example, National Green Tribunal. It is in news because the National Green Tribunal has jurisdictions over a lot of environmental legislation, but it does not have legislation over the Wildlife Protection Act. So this is one of the discussions in our circles, that Wildlife Protection Act is not given to NGT. So this is one of the popular discussions that we are having. And after having spoken about the quasi-judicial body and the regulatory body, this is not a watertight compartment. As I've said before, it is for academic purpose. There are certain bodies which do not have these watertight compartmentalizations. And among them are Securities Exchange Board of India and Reserve Bank of India, and there are many more. So we cannot put a full stop to their actions. This is a very fluid concept, and they take roles of both regulation and sometimes they act as quasi-judicial bodies as well. Moving on, let's move on to the first statutory body of the day, the National Commission for Women. So the National Commission of Women, it comes from a statute, as said before, NCW Act, and as the name suggests, it is a commission for women. It will take care to the grievances of women. Its task is to advise the government. Its task is to frame policies or model acts and ask the government to implement the same. It addresses the grievances. It may call people on hearings and as witnesses, and then it may file a writ petition with the courts. So the composition, they have a chair and they have 5 members. Apart from this, they have a member secretary. The member secretary is an executive person. He is either from the All India Services, from the Civil Services, or any other civil post under the union. This member is for execution and he is an expert in the field. Apart from that, we have the 5 members or the chair who are present. They are supposed to be trusted individuals. And for that, the Act has mandated them to have ability, integrity, and standing. So, for any individual, for any citizen to levy its trust on a body which it is going for a grievance, they need to trust that body. And for that, we need people who are able, who are experts. And for that, the Act has given certain qualifications for these chair and the 5 members. So, who appoints? The Ministry of Women and Child Development. It has executive control over the body. Their term is 3 years and their resignation is addressed to the central government. Their removal is again by the central government. There are certain grounds for removal, but they will be given a fair hearing. Any member, before being expelled or before being removed, they have to be given a fair hearing. One important point here is moral turpitude. This moral turpitude is nowhere defined. The simple act, if it is a moral turpitude or not, this is defined on a case-by-case basis by the central government. So there is nothing which can say that this is an act of moral turpitude or not, except the general understanding of the central government. Moving on, this is the grounds and procedure for removal of almost all the statutory bodies that we'll talk today. So we should remember these points. This is just for so that you can put in your mains answers. Moving on, the objectives is basically women empowerment, and empowerment should be multifold. It should be economic, social, political. So to cater to all this, we have NCW. We have to empower women. We have to assess their status, and we have to see, we have to find out which region do they need more empowerment, what will help to better their status in the society. So all this is seen by the National Commission of Women. Another important fact here is it might take suo motu cognizance in several cases. So where it is convinced that something wrong is happening, which is antagonistic to the interest of women, so it will take suo motu cognizance in these regions, and then it will investigate the matter, and then it will file a writ petition to the concerned body, or it might ask the state, the center or the state to cater to these problems. Moving on, the functions. It has done a lot of functions, and contemporarily it has been active in a lot of spheres. It has reviewed a lot of laws, and out of them, Dowry Prohibition Act 1961 has been reviewed by the National Commission of Women. Apart from that, the PNDT Act, Prenatal Preconception Determination Act, where we try to determine the sex of the baby, and then there are issues of female feticide. So the NCW has catered to these issues, and they have been working diligently to correct the social evils that exist in our society. They have organized workshops and consultations for aggrieved women. And they also constitute committees so that the expertise of the committee can be utilized to develop better policies and better plans. They have also catered to menstrual hygiene. This is a taboo in our society. It's not talked about a lot. So National Commission of Women has taken it up on its shoulders to spread menstrual health and hygiene awareness in our country. So these are the functions of the National Commission for Women. One of the functions of the National Commission of Women was it had to provide speedy justice. And for that, it constituted the Parivarik Mahila Lok Adalats. So basically, we have been talking of a few terms: arbitration, conciliation, and mediation. These are the terms which are being talked about often after we must have read this Singapore Convention. If not, please read it. The most important point here is conciliatory mode of dispute settlement. So the conciliatory mode of dispute settlement is important. I'll tell you why. So a legal procedure, the proper court and justice delivery system, is a long and tiresome one. You have various dates, you have to spend money on advocates, you have to come every day or the dates that you have been assigned for your hearing. So for that, we devised a conciliatory mode of judgment. The whole idea is, main khush, tum khush. So let's resolve these issues amongst ourselves. And for that, we set up Lok Adalats. Lok Adalats in general are an existent system in our legal system, but we also have Parivarik Mahila Lok Adalats to cater specifically to women empowerment issues like divorce, marriages, or justice delivery for women issues. For all that, we have Parivarik Mahila Lok Adalats. So the whole idea is to spare the women of the tedious and tiresome procedures of the court. Moving on, the issues that are associated with this body. Let's talk about these issues. There are various loopholes. There have been various allegations. There have been issues where the commission has been alleged to keep mum. The Me Too movement. 2 or 3 years ago, it started as a very big publicized movement in our country. There were huge hues and cries. There was a lot of blaming and shaming. There were a lot of cases of criminal defamation. But then what? Today, how far have we reached in our Me Too movement? How far are women safe? Has the National Commission of Women actually catered to this? We don't know. We are not in a very good place to tell that how far we have reached and how successful has the Me Too movement been in India. Other issues are politicization, which is a case with almost all statutory bodies or all the bodies that have been created by the state. That there are issues that the members selected or the issues selected are in some way partisan. So these are allegations. There is no justified or proven statement for the same, but there have been allegations. So these are some issues, and how substantive their judgments have been, how substantive their action has been, all this is still a matter of question. So let's move on to our next body, the National Commission for Protection of Child Rights. Again, the statute which creates it, the Commission for Protection of Child Rights Act, administrative control of Ministry of Women and Child Development. The mandate will mostly be children. They have to cater to the demands of children. And the Act has also defined who a child is. Child is a person who is 0 to 18 years of age. There are few things which guides the statute, and it's the Constitution of India. where we have certain articles, 39, B, C, talk about bringing in children of all sections at par with the basic development of the society. Let's move on to our next body, the National Commission for Protection of Child Rights. The statute, the Commission for Protection of Child Rights Act 2005, the administrative control of Women and Child Development Ministry, and their basic mandate will be children, as the name suggests. The act has also defined a child who is a person from 0 to 18 years of age. They are guided by the Constitution of India and the UN Convention on the Rights of Child. Moving on, their composition. Once again, it's almost as similar as the National Commission for Women, except that there is no executive member here. They have chair and 6 members, and it has to have 2 women. They are again appointed for 3 years by the central government. Their resignation is addressed to the central government, and they cater to the needs of children. Their removal is again on the same lines and grounds of the National Commission of Women members. So it has, apart from the other powers, it has a few additional powers. These additional powers comes from the Right to Education Act. It is a regulatory and monitoring authority for the Right to Education Act. It might summon for evidence, it might seek magisterial inquiry. Then again, it has to file a writ petition that this action is not being performed, this section of children are being ignored, this is the institution which is not catering to the Right to Education Act, and all this is also seen by the National Commission for Protection of Child Rights. An important feature in the National Commission for Protection of Child Rights is its bottom-up approach. So the basic tenet of its functioning is it takes each child. It has the mandate to touch each child. So what it does is it takes nuanced responses from the block, district and the state levels and then formulates a plan or a policy for the nation. So it's a bottom-up approach. So the highest emphasis is on decentralization. So every grassroots, it is touching almost every rung of the society. So, and then after it has taken the review and feedback from the lowest rungs of the society, then it formulates national plans and policies. It recommends the central government or the state governments to formulate schemes and policies to cater to the rights and development of children. Few initiatives. It has started the child line 1098. We should try to propagate this. We should try to make it more viral so that this is known to every child in our country. So every social nook or every social node is aware about this. Then there are melas and large gatherings which are children friendly. They have also brought out a standard operating procedure for street children last year. Another important initiative of the NCPCR, they have started a Smart India Hackathon in 2017 where they asked children to come up with innovative solutions, and they have also celebrated the Pariksha Parv. So these are good initiatives which the National Commission for Child Rights Protection has come up with. Moving on, the recent issues. Let's start with an interesting issue, the Bombay Begums. So Netflix has been streaming this show on its platform, and there have been allegations that this show has been glorifying children using drugs. So the NCPCR has asked Netflix to stop streaming this show. The NCPCR has said that this is glorifying practices like drug abuse. So this is one issue which is in focus, which is in the recent discussions. Apart from that, as we've discussed before, there is an allegation that the commission is misguided. So the commission is not catering to the demands of the underprivileged children, or the commission is selective in its issues. It is not picking up the core issues and it is instead emphasizing on publicity issues. So all these are allegations. We do not know how much base they have, but it is one of the issues, and it can be written a point that the commission is alleged to be misguided. Apart from that, a recent issue, the National Commission for Protection of Child Rights has asked last year, around this same time, it had asked states to repatriate 1 lakh children. So there was a huge hue and cry. People were like, these children have been fleeing, or they are in shelter homes for a reason. They are in shelter homes because they haven't got their share of social welfare in their homes, and that is why they are staying in the shelter homes. So when they were asked to be repatriated, the Supreme Court, it took up cognizance of the matter and it asked the NCPCR to take it on a case-by-case basis and not recommend or not order for repatriation of such a huge crowd without taking care of their original whereabouts, or without taking care or without following up about what is happening of their future. So this is one of the issues, and for this we will talk about another related issue, which is child welfare committees. So because the Supreme Court asked the child welfare committees to take over and to take care of these issues, so we'll talk about child welfare committees which were created by the Juvenile Justice Act. It was not created by the NCPCR, and these child welfare committees are state government committees. So they are present in each state. They are supposed to be present in each state. They have a chairperson and 4 members, and they have 1 woman and 1 expert in children. So this is one of our state body which is present, which also caters in adjunct to the NCPCR. They have the following eligibility criteria. Moving on to our next commission, the National Commission for Minorities. So, minorities. What is minority? We have numerous kinds of minorities. There might be religious minorities, there might be political minorities, there might be skin color minorities, gender minorities, there might be age minorities, the senior citizens. So all this is a kind of exclusion, a kind of discrimination that we have developed in our society. So for that, India enacted the National Commission for Minorities Act 1992. Before that, there was a commission, Minorities Commission, which was created by an executive resolution in 1978. But now we have a National Commission for Minorities since 1992. But who is a minority? The Act does not define who is a minority. The minority is defined by the central government in a notification. The central government notifies minorities via an executive resolution. Currently, we have 6 minorities: Muslims, Sikhs, Christians, Buddhists, Parsis, and Jains. So BJP, MSC, these are the minorities which have been notified by an executive resolution in India for the current times. This is not a fixed list and it can be altered any day by an executive resolution. The composition: chairperson plus vice chairperson plus 5 members. Its term is 3 years. Removal by the central government. Ministry, administrative ministry is Ministry of Minority Affairs. The removal is again on the same lines and same grounds of NCPCR and NCW. So the functions basically are to cater to the rights of the minorities. Minorities in India have been facing various issues, starting from mob lynching to discrimination to apprehensions of not being included in the society. So the NCM actually caters to these interests. It safeguards the interests of the minorities. It undertakes and promotes research. So the policies or the schemes that are created in our country, that is created after an effective research done by the NCM, and then it is aggregated to create a policy which caters to their general interests. It also has provisions of grievance redressal. It takes in grievances and tries to address those grievances of the minorities. Moving on, very good initiatives for the minorities in India. One of them is Ustad, that is traditional industries development. Nai Manzil, which caters to the education of the minorities. Seekho aur Kamao is another skill development initiative. So all these are monitored by the National Commission for Minorities. Then we also celebrate the Minority Rights Day on 18th December. So all these are initiatives that the National Commission of Minorities is undertaking. Moving on, how effective or how active has the National Commission of Minorities been? So few instances which I found while browsing was in 2011, the Bharatpur communal riots. The NCM sent an investigating body into the issues of the Bharatpur communal violence. Apart from that, in 2012, NCM also sent a team to tackle the Bodo Muslim clashes in Assam. So all these are good initiatives that the NCM has been catering to. Moving on, the issues. Irregular appointments and numerous vacancies. Talking about this, currently, the NCM has only one member out of the 7 members of the mandated strength. So the appointments are not very regular. In fact, few months ago, when the vice chairperson retired, the Minorities Commission was left with only one member. So how effective can this body be? It does not have an adequate strength. It has just one member. So this is one of the major issues in its functioning. Moving on, the next issue is the lack of tooth. There are allegations that the National Commission for Minorities has not been acting to its full capacity. It has not given enough punishments, or it is not imposed enough fines or penalties for people who are aggrieving the minorities. So this is one of the issues, lack of tooth. Apart from that, it has a non-constitutional status. So it will anyways not have that power as a constitutional body. And another important loophole in the functioning of the National Commission of Minorities is it does not utilize technologies to its full capacity. There are no apps for grievance redressal. There are not enough measures for real-time response, which is not the case with other statutory bodies. Other statutory bodies have a well-developed technological interface, but National Commission of Minorities has not reached that level. So with that, I leave for you to ponder that what is the importance of statutory bodies in our land and how far have they been effective in addressing. With this, I conclude, and I will leave with few moot points for us. First thing, how effective? Second thing, how autonomous? And third, how efficient? We have talked about it in our slides. And I would ask you to put it in our comment section, your responses to these 3 questions, which are moot points for the day. Thank you.